heard about a philosopher, a jurist, an American jurist, Roscoe Pound. He is one of the propounder of a theory called sociological school of jurisprudence. He says that law is a tool, law is an instrument to balance the competing interest. So there are interests which are competing most of the times, and law is there to balance both of them. And he calls it social engineering. So I will be delivering this lecture through an example of snatching. I think that will be very helpful because it will make the narration easy. So let's assume that today in evening at 10 you go out for an ice cream or for a coffee or something, and suddenly two boys come and they snatch your phone and run away. What happens? I hope that doesn't happen to you, but it happens. Snatching is very rampant in Delhi. It happened to a respected member of parliament some days back. So if a snatching happens to you, what would you do? Now you are a victim. You will contact the authorities. As your phone has been snatched, what to do? You will ask a person nearby to give you a lift to the nearby police station. You will go there. You will narrate what has happened to you. You will tell that two people came forcibly, took your phone away from you, and now you are a victim as well as complainant as you are making a complaint to police. Ideally, they are supposed to register an FIR. Why they are supposed to do so? Because the snatching, earlier snatching was considered a theft in IPC under section 379, and it was punishable up to 3 years. And in CRPC Schedule 1, it was categorized as cognizable and non-bailable. And under the new law, it has been made a distinct offense. So now snatching is a distinct offense under section 304 of BNS, Bharatiya Nyaya Sanhita 2023. And it says that theft is snatching when someone forcibly takes away some movable property of yours. And it's punishable up to 3 years. In the Schedule 1 of BNSS, that is Bharatiya Nagrik Suraksha Sanhita, it has been classified similarly as non-bailable and cognizable. Before I proceed further, let me define these two terms for you. By cognizable, the CRPC and BNSS say that when you say that an offense is cognizable, a case is a cognizable case, it simply means one thing, that in those cases, police has power to arrest the accused person without warrant. So once a case is a cognizable case, and such categorization is provided in Schedule 1 of CRPC/BNSS. So if the offense is cognizable, then police is empowered to arrest without warrant. That's one thing. And by bailable, non-bailable, I mean if an offense has been categorized as non-bailable, it means that in those offenses, police can arrest you, but they can't grant you bail then and there. The bail will become a matter of judicial discretion. You would be produced before the magistrate within 24 hours of arrest, and magistrate will decide whether you are to go to the jail or you are going to home. The bail part we have discussed in detail yesterday. Today we are on the side of victim. So the phone has been snatched. You are in the police station. You have made a complaint to SHO, police officer, saying that I have been wrong. Please grant me some remedy. In that situation, the SHO, as per law, as per section 154 CRPC, 173C BNSS, is under obligation as the information disclosed by you is a cognizable information. The information disclosed by you relates to the commission of a cognizable offense. That's why the officer in charge in police station is under obligation to register an FIR for you. And the relevant section 154 subsection 1, I will read one or two lines from that section for you so that some clarity comes. And subsection 1 of section 173 BNSS is very passive to that. I will read subsection 1 of section 154 for you. It says, every information relating to the commission of a cognizable offence, if given orally to an officer in charge of a police station, shall be reduced to writing by him or under his direction and be read over to the informant, and every such information, whether given in writing or reduced in writing as aforesaid, shall be signed by the person giving. The most important part of this subsection is every information relating to the commission of a cognizable offense. So in the center is the categorization, cognizable offense. So the information of snatching relates to the commission of a cognizable offense. And once that information reaches the concerned police officer, he is under obligation to register the FIR. Now, if he doesn't do so, if he doesn't follow the law, what option do you have? You can approach superintendent of the police, his superior in the area, and that is under section 154(3). It says any person aggrieved by a refusal on part of an officer in charge of the police station to record the information referred to in subsection 1 may send the substance of such information in writing and by post to the SP of SP concerned, and he shall, if he finds that cognizable offense, shall either investigate the case himself or direct an investigation to be made by any police officer subordinate to him. That's the law. Law is quite simple. I will reiterate it again that if a cognizable offense has been committed, and if you go ahead and give information of such commission of the offense to the police officer of the area, he is under obligation to register an FIR. And if he doesn't do so, what's the next option? You go to his superior and give him information, and he will register the FIR. And what if both of these people don't hear you, and eventually you are under obligation to approach the court when police doesn't listen you, when SHO doesn't listen you, superintendent of the police doesn't listen you. As per law, they are supposed to listen you when you are disclosing an information relating to a cognizable offense. But if they don't listen you, what do? Then you approach the concerned magistrate. And in section 156(3), 156 subsection 3, it says any magistrate empowered under section 190 may order such an investigation as above mentioned. It simply means that concerned magistrate, competent magistrate, the right word is competent magistrate, who has the jurisdiction over the area, can direct such registration of FIR. So this is the law. So you are wronged and a cognizable offense has been committed upon you. So first you go to police, narrate the incident, give them the information relating to the commission of a cognizable offense. They are under obligation by law to register an FIR. If they don't do so, you go to their superior, that's superintendent of police. You give the information to them. They are under obligation by law to register the FIR. If they don't do so, you approach the judiciary, you approach the competent magistrate, and if he finds that cognizable offense has been committed or the information given by you relates to the commission of the cognizable offense, then he will order the registration of the FIR and investigation. So this is the law, qua initiation of criminal proceedings. So this is the one aspect. Now, there has been a lot of debate. The first debate has been if you go to a police station and give an information in relation to the commission of a cognizable offense, does the police officer has the discretion to conduct an informal investigation or inquiry before registering the FIR? And this is a very big question of law. And that became a topic of discussion. That became an issue in a constitutional bench decision of Lalita Kumari versus State of Uttar Pradesh in the year 2013. That decision was given by a bench of 5 judges, and that bench discussed this topic in quite a detail. I would be taking you through that judgment in a while. So, Lalita Kumari dealt with the question whether the police has discretion to register the FIR or not, or they can conduct their own small investigation before registering the FIR. So I will ask
Yes.
Darsika or Ronak, whoever is having the
Yes,
compilation
sir.
with them. So I would ask them to open the bookmarks, and the third entry would be of question of law. Are we there?
Yes, sir, I am on it.
So please click on it, and you get an
Yes,
highlighted
sir.
portion of this Lalita Kumari versus State of UP judgment. And in the opening line only, see the beauty of this judgment. In the opening line only, they sum up the issue which they are facing. I will read it. The important issue which arises for consideration in the referred matter. Why referred matter? Because it has come from smaller benches of Supreme Court to a five-judge bench. That's why it's called a referred matter. Referred matter is whether a police officer is bound to register a first information report upon receiving any information relating to commission of a cognizable offence under section 154 of CRPC, or the police officer has the power to conduct a preliminary inquiry in order to test the veracity of such information before registering the same. So this is the question which even a five-judge bench has to discuss and decide, because it's a big question. And eventually the Constitution bench articulates the issue. I have given it a bookmark articulation of the issues. So you may see the highlighted portion. At para 22, these issues have been framed, and as we have discussed, the issues are there. So now, as they are going ahead, the first rule which they employ to analyze this section 154 is the literal rule of interpretation. So the literal rule of interpretation at para 36 reads, Ronak, are you there?
Yes, sir, I am on the para 136, over 36.
Okay, good. It may be mentioned in this connection that the first and foremost principle of interpretation of a statute in every system of interpretation is the literal rule of interpretation. All that we have to see at the very outset is what does the provision say. As a result, the language employed in section 154 is the determinative factor of the legislative intent. A plain reading of section 154(1) of the code provides that any information relating to the commission of a cognizable offense, if given orally to an officer in charge of a police station, shall be reduced into writing by him or under his direction. There is no ambiguity in the language of section 154, subsection 1 of the code. So they say that, okay, we will simply read the section, and that's called literal rule of interpretation. Whatever has been written, read it like that only. And they say that after reading it, we can only make out one thing, and that thing is that if you receive the information which discloses commission of a cognizable offense, you are under an obligation to register the FIR. So this is the employment of literal rule of interpretation. Then analysis of these sections, section 154, section 39 CRPC, and eventually they come up with this thing only, that it's mandatory to register the FIR. And there are other things like where to write the FIR. So they say that this thing has been decided in the case of Madhubala, wherein they say that you need to have a proper register, and that register is for registering the FIR, and that register is to be maintained very nicely. In the course of this hearing, there are two rival submissions, and these rival submissions, one of the submission becomes the law of the land, that's the judgment of Lalita Kumari. Another submission doesn't get accepted, but if we will see in the later part of this judgment that it becomes part of BNSS, and now in a way is the law of the land. So first of all, we will see the argument which became the law of the land and the conclusion of Lalita Kumari judgment. So this argument is of K.V. Vishwanathan, ASJ. Now Mr. Vishwanathan is an honorable judge of Supreme Court of India. Then he was Additional Solicitor General of Union of India, and he submitted that at para 11. He submitted that in all the cases where information is received under section 154 of the code, it is mandatory for the police to forthwith enter the same into the register maintained for the purpose if the same relates to the commission of a cognizable offense. So this is what he says, that information comes to you, it discloses commission of a cognizable offense. Now you don't have an option, you register the FIR. Another rival submission is by Mr. Luthra, Mr. Siddharth Luthra. He is a known criminal lawyer and a jurist. And he says that no, you can't do so. You need to conduct a preliminary inquiry. And before para 18, there are 4 5 lines in the next page. I will read those lines. He 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 substantiates his argument by showing the consequences of not doing a preliminary inquiry. Further, he emphasized that the power to carry out an inquiry for or preliminary inquiry by the police, which precedes the registration of FIR, will eliminate the misuse of the process, as the registration of FIR serves as an impediment against a person for various important activities like applying for a job or a passport, etc. Learned ASG further requested this court to frame guidelines for certain category of cases in which preliminary inquiry should be made. So he is talking about consequences. Okay, we can go ahead and say that you register the FIR without an inquiry, but what if the information is wrong? Because against the person against whom the FIR is going to get registered is going to suffer some consequences. So the next thing comes if you see the bookmark named is conclusion oblique directions of the Constitution bench. It's just below the index. I am there. Ronak, are we there?
Yes, sir, on it.
Conclusion oblique directions. So the first conclusion is that information discloses cognizable offense, you register the FIR. That is the first conclusion. But the conclusion sixth, there is some middle path. It says, as to what type and in which cases preliminary inquiry is to be conducted will depend on facts and circumstances of each case. The category of cases in which preliminary inquiry is to be conducted are matrimonial disputes, commercial disputes, medical negligence, corruption, and all these cases. So the law has been laid down. And I think in conclusion, we need to read the conclusion too, because it's very important. If the information received does not disclose a cognizable offense, but indicates the necessity for an inquiry, a preliminary inquiry may be conducted only to ascertain whether cognizable offense is disclosed or not. Now the tricky part is, it doesn't say that inquiry or preliminary inquiry is out altogether. It says that your job is to find out whether a cognizable offense information has reached you or not. So if the information says a cognizable offense has been committed, register the FIR. And if the information is little bit doubtful and you don't know whether a cognizable offense has been committed or not, you conduct an inquiry. And if after conducting the inquiry you find that okay, there is some seam balance, there is some information for commission of cognizable offense, you register the FIR. If you find that okay, there is no information in relation to the commission of a cognizable offense, you don't register the FIR. And the scope of preliminary inquiry is just that only. The preliminary inquiry is not to ascertain the nature of the case. It's just to ascertain whether it's related to a cognizable offense or not. You are not going into the merits of the case. You are trying to find out whether these allegations somehow disclose commission of a cognizable case or not. And in which cases this has to be done, particularly have been delineated in para 16, matrimonial disputes, commercial disputes, medical negligence cases, because these cases are per se complex and involve a lot of appreciation. So this is the law of the land, and it was fine till 2023 when BNSS came. BNSS became operative on 1st July 2024. So let's see what changes BNSS have brought in. So there is a very famous case, Facts of Imran case. So if we click on that bookmark, I will go a page prior to that. The case name will be visible. Imran Pratapwadi versus State of Gujarat. It's a free speech case. So on the page, para 2, so there is a parliamentarian who has recited a poem, The poem is visible for you. And some gentleman went to a police station saying that he has tried to harm